afternoon, everyone. Welcome. My name is Jen Coatsworth, and I am the 2024 Chancellor of the Philadelphia Bar Association. We're so proud to host this program on behalf of our partners in the First Judicial District. And I'd like to give a special thank you to Judge Anders for his work in organizing today's webinar, which focuses on a critical topic that's important to so many of us in the legal community. So we're presenting this program in partnership between our state civil litigation section and the FJD, largely because our section has formed such a strong relationship with the First Judicial District and offers monthly town halls with updates from the courts, along with periodic CLE programs and the latest trends and top-of-mind issues in the practice area, including trial skills and case management best practices and more. So we hope that you will find today's program informative and comprehensive, and that you'll come away with some practical tips that you can immediately apply to your practice. And with that, I will turn the program over to Judge Anders and thank him, along with Judge Schulman and our panelists, for presenting today.
Thank you, Chancellor Coatsworth. It's always a delight to be with you. And thank you to the Bar Association for hosting this webinar. We turn to the Bar Association to host for the webinar because we get so many people who are interested in hearing about this program. And we appreciate that strong connection between the FJD and the Bar Association. I'm going to start with our PowerPoint slide. And I can do the, let's see, slideshow. There we go. All right. So we have an update 1 year later, just over 1 year later, on how we're doing in the medical malpractice program. Our speakers today are myself, Judge Schulman, who's our judicial leader for the medical malpractice program, Rob Ross of Ross, Feller and Casey, Heather Tereshko from Post and Shell, and Beth Persun from from MCARE Fund. She's the Director of Claims Administration. In terms of topics, Judge Schulman and I will provide an update of our medical malpractice program, including new case filings, settlement conferences, protocols for pretrial conferences, and expected trial dates. Then we'll have Ms. Tereshko and Mr. Ross discuss their firsthand experience on interacting and complying with these protocols, as well as how to successfully resolve cases earlier. And then we'll have Beth Persun provide a statewide perspective on managing medical malpractice claims, as well as the many resources that MCARE has to assist parties in resolving their medical malpractice claims. As a result of the venue rule change, we had a substantial increase from our normal annual filings. If you look at the first three columns, 2017 to 2019, that's an average of 410 medical malpractice cases filed in a year. 2020, 2021, 2022 are lower, mostly because of the pandemic impacted the number of filings. And in 2023, with the new venue rule change, we increased to 544. It's about a 33% increase from where we were before the pandemic. And as I said to you a year ago, we were ready to meet this challenge, and we wanted to undertake some changes in the protocols that we have, and to make sure that we were able to not only eliminate the inventory that we had built up during the pandemic, but also get prepared for the new cases that were being filed. If I can do a bit of a review of what we did in 2023, as I just mentioned, there was a 33% increase in the number of medical malpractice cases filed in Philadelphia. That went from 410 to 544. There was a 27% increase in the number of medical malpractice settlements in 2023, and notably a 61% increase from July to December of 2023 compared to what we were settling per month in 2017 to 2019. One of the protocols that we implemented when we were looking at this program a year ago is that we changed the circumstance under which you get a pretrial conference. You no longer get a pretrial conference automatically. You only get one scheduled if you provide a certification that the X reports have changed. Have been exchanged. And early in the year, we were scheduling 51 pretrials per month. The reason for that high number of pretrials is because we were dealing with that COVID backlog. By the end of 2023, we were averaging 20.6 pretrials per month, which was that lower number as a result of we've cleared out the backlog of cases, and there was some adjustment period to lawyers getting ready for the new case management protocols requiring the exchange of X reports. And in 2024, I expect that the average number of pretrial conferences per month will probably increase slightly to 25, and maybe in 2024 or 2025, we'll look maybe something close to 30. But the good news is, with less pretrial conferences being held per month, that reduces the likelihood of double booking of the lawyers. Other items that occurred in 2023, we were able to, by the end of the year, adhere to assigning earlier trial dates at the pretrial conference. When we started in January of 2023, the trial dates were much later, or much more delayed, maybe 8 months to a year. By the end of the year, we've been able to meet our promise, which is if there's no offer at the pretrial conference, you're being scheduled within 90 days. That is a case that you've indicated to us is a must be tried or a no offer case. All the other cases will be scheduled for trial generally within 6 months. We expect fewer trials to be scheduled in 2024. Again, if I look back in the latter half of 2023, we were scheduling 10 to 12 medical malpractice cases every week for trial. The number of actual cases that went to trial was between 2 and 4 cases, but we scheduled 10 to 12 medical malpractice cases, including double and in some cases triple booking lawyers to get through that inventory. In 2024, I've capped the number of medical malpractice cases to be scheduled in any particular week to 8. So the most number, instead of 10 to 12, will be 8 throughout 2024. And the last point I wanted to make about how we're scheduling trials is that we have, as of today, only 7 medical malpractice cases that are scheduled after September 1, 2024. We have nothing scheduled more than a year out. And if you go back just 2 years ago, 20% of our medical malpractice cases had trial dates more than 1 year from the date of pretrial conference. When we were hosting webinars last year, we did 2 webinars last year. I told everyone we have to adhere to the National Center for State Courts and their guidelines on disposition of cases. They want us to dispose of our cases as close to within 2 years as possible. And I'm very pleased to report that we are in as good a shape as we've ever been before the pandemic, and certainly during the pandemic, in terms of meeting that expectation. What do we expect in 2024? I will continue to monitor the monthly filings. It looks like we're settling into a number that's around 45 filings per month, which will be the new normal for Philadelphia. I expect the number of pretrial conferences, as I said before, to slightly increase as counsel adjusts to the requirements for that pretrial conference. The length of time from the pretrial conference to the trial date should remain within 6 months for most cases. There are times when there is an extraordinarily long trial that might be 3 or 4 weeks that we will push further out. But for the most part, we want these cases to be scheduled for trial within 6 months of the pretrial conference. And to accomplish that, double booking remains an option for Judge Schulman. When you are double booked, the earlier attachment order control. So we're not going to make a lawyer decide between clients. The later attached case will be continued if the attorney is attached on two cases starting the same day. So if Ms. Tereshko is representing a client and has two cases scheduled for trial this Thursday, we will only have her on one case. The other case will be continued. So again, we're not going to put Ms. Tereshko in a position of deciding which client to represent. It would be the earlier attached case that would go forward. And then just in terms of practical aspects, only 3 out of nearly 300 trials that have been scheduled were impacted by a double booking, meaning that one of the cases had to be continued. There have been a few circumstances where a trial lawyer was concluding another case that had started a week or two earlier, and it ran over the number of days allotted. We may, in those circumstances, continue the jury selection date by 1 or 2 days to accommodate that trial attorney schedule, but we really do intend to keep those dates as firm trial dates. And I'll turn it over to Judge Schulman. Judge Schulman will review all of the different conferences that we have and the protocols for each of those conferences. And Judge Schulman, you're on mute.
Rookie mistake. Thank you, Judge Anders. As most of you know, there are a number of conferences and interventions that we built into this new protocol in order to help the bar as well as us deal with this big bulge of cases that we had to deal with last year. So the one-year conference was a new idea. Some people thought maybe not such a great idea, but as it turned out, it's become a very popular idea, and we get very, very helpful feedback that the one-year conference really does start to have attorneys zero in on their cases. I'm going to be asking about your discovery process, where you are in discovery, whether there are any special problems that need to be addressed, when you need to go to your team leader to address those problems, instead of just letting things linger on. The idea being that it's the first stage, a year into your case, we would like to see that counsel is certainly finished with written discovery at a minimum, and should already be starting to or have taken depositions, particularly in these cases where there are multiple depositions. You know how difficult it can be when depositions get canceled and have to be rescheduled. Then you start coming up against the discovery deadline. Then you have to go back to your team leader and ask for more time. So this seems to be a helpful vehicle. It does take a lot of time. I touch every single med-mal case that is filed. So it does take a lot of time to do. We were doing this on a more of a trial basis to see what the response is and how well we were filling a need, and we've had just an overwhelmingly positive response to doing this. So I will continue. The plaintiff is expected to make a reasonable demand in their one-year conference memorandum. This is not optional. This is a requirement. We have been talking about it, and I've been talking about it, certainly at the last webinar. It's incumbent upon plaintiff's counsel that if they want a response by defense counsel to a demand, the demand needs to be made early and it needs to be reasonable. So if you're not making a demand in the one-year conference, your one-year conference will most likely get canceled. until a demand is made. Moving on to the 90-day conference. So the 90-day conference is at the opposite end of the litigation trail. So that's 90 days prior to trial. The sole purpose of a 90-day conference is to determine whether or not your case should be referred to a JPT for settlement conference. Peter Hoffman and Dan Sherry have volunteered their time to conduct a 90-day conference. And again, that's on every single med-mal case that we have. Very short, very quick. You don't have to file anything ahead of time. All you need to know is whether or not there's been a demand made to an offer made in response to plaintiff's demand. Where there is a reasonable offer made, the case will be referred on to a JPT settlement conference. The JPT settlement conference program has been extraordinarily successful and popular, as we expected it would be, due to the exemplary nature of the attorneys that we have volunteering to serve as our JPTs, highly experienced medical malpractice attorneys, as well as our 2 senior judges. And whether or not a case settles directly at the conference or whether it settles sometime after the conference, those cases are certainly a successful result from our JPT program. Oftentimes, the JPTs will not only give you a 3-hour slot for your conference, they'll follow up with you where it seems that it might be productive. They'll have another session with you. They have been extraordinarily generous with their time. It can take 2 to 3 months to schedule a JPT conference. So there are many points along the way that you can ask for one. You can certainly ask for one at the 1-year conference. You actually can ask for one before the 1-year conference by contacting my chambers and telling me that there is a demand, there is an offer on the table. We think we're ready to negotiate in good faith. I will send you off to a JPT. At any point in the process, the 1-year, the pretrial conference, and thereafter, it becomes a little harder. So if the first time you request a JPT settlement conference is at the pretrial conference, it can take 2 to 3 months to get it scheduled. You'll get onto a scheduling appointment with Pete Devone. Pete will match you up with a JPT according to their schedule. So that can take some time. So make every effort that you can so that before the JPT conference, you know if you're going to be asking to be referred. Even after, we have limited ability to set up a JPT conference at any time after the pretrial conference. That's not to say it can't happen. Oftentimes, someone like Peter Hoffman will jump in and say, yes, I can, but that's not always the case, and you certainly should not be counting on that. As far as, I'm going to hold off on the other conference, which is the trial readiness conference, to our next slide. So we can go on to the protocols for the pretrial conference. Pretrial conferences have become much more substantive than they were, mostly because what we're talking about at the pretrial is that we are looking, and I am looking for answers to questions such as what is the plaintiff's demand and what is the response to the demand? At the point that you go to the pretrial conference, all expert reports will have been exchanged. And that's been a major change in the way that you are practicing. We can no longer just allow the exchange of expert reports to linger on and on and on past the pretrial. Now you will not get a pretrial conference unless you e-file your certificate of compliance, which says that all sides have exchanged their expert reports. Not just that plaintiff has given the defense their expert reports, but that defense has also given plaintiffs their expert report. It's then on plaintiff's counsel to file that certificate of compliance. And what the certificate of compliance does is it triggers your pretrial conference. So you're not going to get a pretrial conference unless you've complied and a certificate of compliance has been filed. Where we know that it's been time for a certificate of compliance to be filed and it has not been filed, and we can track along and are tracking along the filings in each case, then you're going to get a notice for a rule hearing, which is a potential sanctions hearing for failure to file your certificate of compliance. That has also been a major change, major difference from what was happening before. We only instituted the rule hearing component of this at sort of the end of our protocol process, because we still weren't getting the cooperation that we were hoping for in exchanging the expert reports. Now that I believe most practitioners know that they will go to a rule hearing and they may be subject to sanctions if in some cases there have been multiple discovery extensions, multiple granting of motions for extraordinary relief, and expert reports still are outstanding. That's when you're subjecting yourself to a potential sanctions order. If you file that certificate of compliance even the day before the rule hearing is scheduled, you don't have to come. We'll cancel the rule hearing. So I don't think I've issued a sanctions order, or maybe I've issued one or two in the past 4 or 5 months. So that is also working out well at this point. At the pretrial conference, if there is no offer at the pretrial conference, and counsel is expected to make a reasonable offer or communicate privately to me that there is authority to settle if you don't feel comfortable making the offer, or state, look, it's a no pay case, this case has to go to trial. One of those 3 answers. Where there is a reasonable offer or a communication of authority, then counsel can ask for a JPT conference and I will send you on to get scheduled for one. That trial gets scheduled within about 6 months out, because we need to give you time for that pretrial conference. It may be less than 6 months, but it will be at least within 6 months. Also, where it's appropriate, counsel would need to confirm their tender to MCARE. In all other cases where expert reports have now been in your hands for about 3 months now, we expect that case is ready for trial. And those are the cases where counsel should expect to go to trial within 90 days. As most of you know who've been on pretrial conferences with me, sometimes it may go a little longer than 90 days, depending on the length of the trial. We have so many slots for 5-day trials, so many slots for 10, so many slots for 15 and 20. A longer trial will most likely be scheduled later out, but not necessarily, because our trial schedule is like a living, breathing organism. So if a 20-day trial settles, all of a sudden I've got a big 20-day slot to fill, and that may be within 90 days. So if you've seen that there's been some variation, that's why. It's because as cases settle, I am gonna fill those slots up.
And Judge Schulman, just to be clear, if a lawyer comes in and says, I expect authority, I expect to have an offer, that's not good enough. They're gonna
Not good enough. And
Okay.
and honestly, that's the most common answer. So thank you for bringing that up. That is the most common answer, as it has been for such a long time. But that's not good enough. So the whole point is have the answer at the pretrial conference. And if you don't, it's unfortunate that your clients are not giving you that opportunity to come to the pretrial conference and go to a JPT or extend your trial time because real negotiations are going on. So when the answer, and most likely, most often, that is the answer, where I'm going to have authority, it's not a no pay case, but I don't have it yet, that case is going to trial within 90 days. So also, it has been, I've seen an uptick in the private communication of authority to me, and that's perfectly fine. I expect it to be, of course, not nuisance value. It would have to be an earnest offer. And the other thing that needs to be emphasized about going to a JPT conference is that the purpose isn't just to show up with one demand and one offer and we're not moving from there, because then what's the point of sending you to a JPT? We expect that you're going to be negotiating in good faith at the JPT conference. There will not be continuances. Once a trial date is given, that trial date is written in stone, unless there is an extraordinary circumstance. So when you come to the pretrial conference, you need to know all of your unavailable dates, all of your witnesses' unavailable dates, because coming back later on to say, well, I didn't know my witness was going on vacation, we can't, unfortunately, we just don't have the flexibility to accommodate that. The trial readiness conferences also, that's a brand new mechanism for our Med-Mal program. Again, I think they've been extremely helpful. They are very time consuming. The purpose is to identify your motions in limine, try and pare them down. I'll often ask counsel to send an email to me so that I'll then forward to the assigned trial judge with the most important motions in limine and priority if you need them decided before openings, and then ones that maybe have been agreed upon or can be withdrawn. We also talk about whatever prior trial attachments, and that's where the jockeying may go on back and forth. If there is a prior trial attachment, is that case already underway? Is that case possibly going to settle? Oftentimes the cases have settled by the time we get to the Philadelphia pretrial, for not just Philadelphia, but the current pretrial. The other thing I just wanted to mention, I know that we have held the trial readiness conferences at different times during the week, and we've given often very little notice, and that has been a function only of my trial schedule. So we have, and we heard a complaint and we're responding to that complaint. So the trial readiness conferences will be on Mondays at 3:30, unless there's a holiday that day or for some reason my trial schedule won't permit it. But we are cognizant that you want much more time for the trial readiness, and perfectly understandable. All right, thank you. Go ahead. Judge Anders.
Let me just end with a few comments. When you have a minor's compromise and you've settled or a wrongful death petition, and you're filing that with the Orphans Court and Judge Wood Skipper, please note that in order for you to get expedited consideration, you must have provide notice of the settlement and the copy of the petition to the Department of Human Services. There is an email address in this slide for you to do that. And when you do that, and the letter indicates that there's no objection to the settlement, Judge Wood Skipper will expedite her consideration of the petition. The other thing I wanted to say, and I think we're going to notice the settlement. When your case settles, please e-file that settlement letter. It's the easiest and fastest way to notify us. That is monitored throughout the day and into the evening. You can email or fax the team leader or assigned trial judge, but that does not substitute for your e-filing the settlement letter. And please e-file as soon as you've reached that material terms of the agreement. Don't wait until the petition to approve settlement has been approved. Do not wait until the funds have been received. Let us know earlier, because we can clear the way and make room for other cases. Before I turn it over to Beth, I just wanted to say that, on behalf of Judge Schulman and I, we can't be more proud of what you all have been doing in helping us reduce our inventory, clear through the backlog, and get current. I had maybe what I could say reasonably stern words for those with us in May about where we were and where we needed to go. And I think I can say we've actually gotten there. We've gotten there before I thought we would. We also talked about changing the culture. And before we implemented the rule about 90 days and going to trial, Judge Schulman, I should say, held more than 200 pretrial conferences, and there were no offers in any of those pretrial conferences. Now, with all the protocols we've put in, the time that the clients have with the expert reports, having a demand 1 year in, the availability of the JPTs, there are some months where it's probably exceeding 50% of the cases where pretrials have offers. Sometimes it goes a little lower, but the fact that now a significant percentage of cases have offers at the pretrial conference, that is changing the culture. And I think it's changing the culture for the better, that these cases, rather than putting time and effort in preparing for trial, you're settling the cases that should be settled, and we're going to focus on trying the cases that should be tried. I've said this before, we're trial judges. We want to try your case if the case has to go to trial. If it's going to settle, we want you to settle it as early as you can. And so with that, Beth, if you want to introduce yourself, and I think you probably need no introduction to many of these people, and then I'll turn it over to you.
Okay, thank you, Judge Anders and Judge Schulman. Beth Persun, I'm the Director of Claims Administration at the MCARE Fund. And today I want to share an overview with you of 3 areas, beginning with MCARE's financial results the past year as compared to 2022. Overall and specific to Philadelphia, our ADR program, which includes an emphasis on consideration to binding arbitration in lieu of trial. And I'm going to tell you about how successful this is looking. And lastly, MCARE is a resource in case resolution, helping to help some folks get to beyond any impasses. So starting with results, MCARE staff has kept pace with the court's goals of expecting that a significant attempt is going to be made at settlement to settle cases that should be settled rather than tried. And as an insurer, if you're an insurer there, you are feeling the pressure perhaps of a greater number of cases where offers need to be made, but you have a lot of company, not only in Philadelphia, but across the state. The catch up on case disposition due to the pandemic is noticeable everywhere. So as you know, our claims year begins on September 1st and ends on August 31st. So instead of a calendar year, which we've been discussing, we have to focus our review. When I'm talking about 2023, I'm really talking about part of 2022 and into 2023. We're currently in the claims year 2024. Our paid claims going back to 2021, which was severely impacted by the pandemic, and partially in 2022, showed the slowing of this cadence to settlements that we normally see. The filing dates of cases that were settled during the 2023 claims year indicated that the majority of those cases are older cases. The 2023 claims payments totaled $242 million. That represented 342 cases and 498 claims. This was an increase of $70 million over 2022, which was $172 million and 85 less cases. Our payments last year in Philadelphia cases was $63 million, which is 26% of our total payments. But that percentage was within the range of what we typically see in Philadelphia. All three regions of the state showed an increase over 2022. Our total in the East, which is 7-county region, was $114 million. Central was $59 million, and Western $68 million. We do expect always to see higher numbers in the East because of the concentration of healthcare delivery here. Philadelphia County alone has 37 hospitals and the highest population in the state. So now we're 6 months into claim year 2024. And since September, every month has exceeded last year's monthly committed payments. These settlements continue to be cases that for the most part were prior to the pandemic and during that period. Very few are of 2023 filings. And the high majority are fully developed with discovery completed or near completion. So as many of you know, we respond to claims where our coverage is triggered by a tender of the primary limit. So we can't fully predict what is going to happen through the end here of the 2024 claim year. But we do anticipate that it will be an increase over 2023. The summer largely represents what payments will be made by MCARE because there is that big push. We have a deadline of August, and we do see that. And as Judge Schulman's conferences continue to occur, we do ask that you consider the severity of the case and that MCARE would possibly be involved. And please get us your report of first claim and the documents of what we need a lot of documents. We'd like them all along, but what's critically important are those evaluative reports that are provided by defense counsel and plaintiff's counsel, along with the expert reports. We have a concern that in some circumstances, we're getting very late information along with tenders, and that slows our ability to respond to you, along with being very difficult to push other matters aside, which now has become an emergency, which wouldn't have been otherwise. And for the insurers who are listening, whether you decide to tender or not is, of course, entirely up to you, but we just appreciate if you would get us the information so that we can be prepared should you decide to do that. And we always keep confidence in whatever it is that you're providing to us. The second thing I'd like to get to, though, before we get to this slide, Judge Anders, is our ADR program. I'm going to give global numbers and then give you specifically Philadelphia. And since 2003, many of you know that MCARE, this is a hallmark of what we like to do. We've been involved in over 2,500 ADR processes. It continues to be highly successful and very much accepted. This past claims year, which is 2023, we completed 157 cases That was comprised of 51 arbitrations, 100 mediations, and 7 cap agreements during trial. And what did Philadelphia have out of that? Well, 32 of those 100 mediations were Philly, 9 binding arbitrations out of the 51. And so far this year, September to February, Philadelphia has had 18 mediations out of 48 completed across the state, 5 binding arbitrations out of 16 completed. And here's the great news that I'm wanting to share with you. We currently have 10 to 12 binding arbitrations today that are in process. And it really shows that increase in Philadelphia of accepting binding arbitrations. This has a lot of momentum, and it's a really good way to get your case resolved and not have to go through the expense and uncertainty of trial. And they're all binding and with very specific signed agreements. Usually they're 5 to 8 pages. They cover absolutely every potential outcome. So there's no question as to what will be the outcome with the decision, who's going to be involved, who will pay, and when it'll be paid. There's a tremendous certainty, and MCARE writes the agreement in consultation with the payors and attorneys. The arbitration's typically conducted over 1 to 2 days, and that's a manner in which is just agreed on between plaintiff and defense. Usually there's some live testimony and obviously some report submission, with it only being 1 to 2 days. Now, these can be scheduled way out. We haven't been seeing that as much as we would like to. Typically, they're coming in right before a conference and, let's take this to a binding arbitration. But if plaintiff and defense and the payers are willing to do so, you can schedule these out 5, 6 months if you need to, if you have a trial date coming up and you already know. Not that we're encouraging you to do that, but there's many possibilities. And also, if you choose to mediate and the case doesn't settle, it's possible you can still then go into a binding arbitration. So there's just many things that can be done. MCARE has experience with over 50 different mediators and arbitrators over the years, and we don't have a list intentionally. With mediators, medical malpractice experience that's coupled with ADR training and Pennsylvania specific experience with med-mal is really what's needed. And usually it's defense counsel, plaintiff's counsel are being used. Professional mediators are very successful with this, and retired judiciary. The arbitrators have the same background, but there is a preference to use retired judges, and that's because it is a binding proceeding, so it just lends itself to wanting that certainty of how the decision is going to come about. And so if you're interested in hearing about our ADR program, I'm going to make my pitch. As a potential mediator or arbitrator, please contact us. We'll go through how facilitated mediation is done. There's plenty of opportunities for those who have this prerequisite experience. And we're hoping that you will look at your cases and consider the possibility of reaching out to the other side. See if they'll be willing to consider a binding arbitration. We've now done over 500 of the arbitrations. You can see mediation is much more popular with that 2,500 number. But this is really an effective and acceptable way to go. And then lastly, I'd like to move on to using MCARE as a resource in case resolution. Since we have coverage for all MCARE participating healthcare providers in a case, we approach cases similar to a facilitative process. And because we see all catastrophic cases, we likely can answer questions. When you call us, you can bounce ideas around with us. Judge Anders has just put up an MCARE case evaluation. If we have a tender, we are glad to discuss the values with you and other aspects of your case. And while we, again, cannot give confidential information. We can meet and go over the particulars of the analysis, share what our experiences have been, including many of the subjective points that you might have questions about. We want to freely share this, as well as our process if you're not familiar with it. And so Pennsylvania, I guess I should mention Judge Anders' slide here is on evaluations highlighting aggregate limits where a primary is exhausted, MCARE's in drop down, and we will always conference that case with you. We'll get an overall valuation on it. This is just, we want you to be able to utilize the experience we have. And then Pennsylvania MedMal, in large part, is still global resolution. Yes, some joint torts occur, but we want to keep it global and get that entire case resolved. We can establish a conversation among the insurers and the attorneys where it appears as though you might have a lapse in communication. You might even want to consider defense mediation. This is something that is not used that often, but again, probably should, where you have a lot of players involved who may not be as familiar. You all get together before you get the plaintiff approached and frustrated with the process on a case that should be settled. And then there'll be a greater chance of getting a global resolution. So finally, I just want to say that there are some law firms that we are seeing recently handling cases that are new to Pennsylvania MedMal. Usually, it was a smaller bar, but now we see there's, more of a spreading amongst firms. And we would be glad to present to you about MCARE and our observation of how things are often done overall. A few firms have reached out to us and asked to schedule a meeting. So please contact me if you want to arrange that, and we'd also have you meet our staff. So thank you.
Beth, there are a few questions. First, is there a list of approved MCARE arbitrators?
There is not. And again, thank you for asking, because I want to overemphasize that we look to the experience that is the background of the potential arbitrator or mediator.
Next question, will the fund keep confidential the fact that a tender has been made?
Yes. And that is presumed, and our staff will not share that information. There may be cases where you are asked, is it all right to share that there is a tender, because that sometimes facilitates others than getting involved in that settlement.
And then last, are most of your arbitrations binding high-low?
They're binding arbitrations, and the high-low features are certainly something that's attractive to most of the payors and the attorneys, because they're, depending on the case, you want, there's always risk both sides. So assuming that risk, you also want to be sure that you can satisfy your client, if you're the plaintiff, that there was a chance of a defense verdict and now we might have some money coming regardless. And you also have that on the other end of the spectrum, that there's certainty that there would not be an appeal. So yes, it is a popular way that things are resolved.
One last question, who approves the arbitrators, MCARE or the carrier?
Everyone involved in the case. So we have to have defense and plaintiff, and that's why I think it's been so just so successful. And we haven't had any of these agreements overturned. I mean, I'm afraid to say that. I mean, that's just a tremendous success rate, and it's because we communicate down to absolutely every detail. And obviously, if the plaintiff or the defense is not happy with the proposed arbitrator or mediator, we just keep going. We just keep talking about, we're just very fortunate to have a lot of experienced folks. But again, saying what I did previously, we want more that feel that this is an area that they have a particular affinity to doing.
Great, thank you, Beth.
Thank you.
and two lawyers who need no introduction, but I'll give it to them anyway. Rob Ross and Heather Tereshko are both here. I'll leave it up to each of you to figure out how to divide the time.
Heather, if you want to go ahead and begin, I'll just follow you.
Sure. Thanks, Rob. Good afternoon, everyone, and thank you, Judge Schulman and Judge Anders, for holding this conference and for inviting us to participate. I think it goes without saying that the past several years have been unprecedented times for being a medical malpractice litigator, not only in Philadelphia, but across the state. Each county seems to have their own set of rules, and Philadelphia is certainly at the forefront with getting cases moving to trial very speedily, and certainly creating protocols to engage the parties in early settlement and early resolution. I'm hoping we are at the tail end of feeling like we're all in this pressure cooker, and that once we get used to this new normal, that we'll all everything will go smoothly, and we can only hope for that. For now, we're trying to try our cases, even when we get double and triple booked, go to hearings, depositions, respond to discovery, everything that a medical malpractice litigator has to do, we are doing, and I think we're doing it well. Producing reports on time to our opposing counsel is now the rule and not the exception under the court's new protocols. And I think the court's program has been highly successful, not only in keeping all counsel and their respective clients on a very tight deadline for the exchange of expert reports, but also in helping counsel, especially defense counsel, to keep their clients informed in a timely manner so that their clients can appropriately respond in time for a pretrial conference where Judge Schulman is going to ask, why isn't there a settlement offer? Or, what are you doing to try and get this case resolved? Obviously, we want to go into these pretrial conferences with a firm position and getting the information as defense counsel, getting the information to our clients for them to evaluate early is ideal. And obviously, from Beth's perspective, our client's ability to get the information to MCARE is even more ideal than anything to try and get these cases resolved. The best tip I can offer is the most obvious one, and clearly to everybody on this conference who's an experienced litigator, getting your experts engaged early and often, I think, is the best tip that I can provide to any young litigator or even experienced litigator. We try to do that. As defense lawyers, we are frequently 12 to 24 months playing catch up. So we know that our colleagues on the plaintiff's bar have gathered records for a year, perhaps. They've identified experts. They're really kind of in control of the narrative of the case. And then defense counsel is assigned after the case is filed. And frequently we have to wait, could be a month, it could be a few weeks for medical records. Sometimes it's a lot longer than that. But ideally, our clients, most of our insurance clients, prefer that we have our experts retained, identified and retained, and reviewing the case and providing feedback within the first 90 days. That's not always easy when you're trying to juggle all the other balls that you have to juggle. But one of the other tips I would provide to everyone on this conference is we try to delegate that. So within our own pod, so to speak, in our at Post and Shell, we have some really intelligent, dynamic, creative people who are able to look at a complaint, figure out what types of experts are needed, and go on to different health system websites and identify those experts. That's a huge leg up for me, so that I'm not spending the time doing that and someone else is already getting that done. So that obviously having lots of extra hands is helpful. Some of our clients actually require multiple expert reviews, and that's the other thing I would recommend. I've been in a situation where it was time to produce expert reports. We received the plaintiff's expert reports, produced them to all of our experts, and then we found out that our expert was no longer available to review the case. And so now you're 30 days away from a deadline, and you're scrambling, and that's not it's not a good position to be in. It's a less enviable position to be in front of Judge Schulman or whoever is conducting a rule hearing where you're potentially going to be sanctioned because there hasn't been an exchange of expert reports. That negative to me is so low down in terms of the overall positives that have come out of this program. We are all getting accustomed to the new, like I said, the new normal, and identifying the experts and really just keeping track of our deadlines and ensuring that we can meet our deadlines in a timely fashion. I would say that there have been times when I've been approached by plaintiff's counsel who's asked for a brief informal extension of time. I think that agreeing to informal extensions of time is kind of done at your own peril. It's just not a comfortable position to be in, to tell your client that you have to go to a sanctions hearing because reports have not been exchanged or a certification hasn't been filed. I do think everybody is working very hard to ensure that they are meeting these deadlines, and they will continue to work hard. And I think going back to what Beth said, the sooner we get these evaluations from our experts, the sooner we're able to report that information to our clients, who in turn can decide what to do with that information. We have seen most recently quite a few cases with one of our clients, seen cases get resolved in fairly short periods of time because we were able to provide lots of information in terms of what the plaintiff's experts were saying, what the exposure was, what the defense experts were saying. And that's just obviously an ideal situation when you know you have a case that needs to be resolved and should be resolved, and you don't want to wait until you're sitting or standing, I should say, on the courtroom steps to try and resolve that case. This isn't really brain science. We know what we have to do. We see these cases. We're experienced litigators. A birth injury case comes in, a stroke case comes in. We know what types of experts are needed. And ideally, it's just getting those records out to the experts, getting them reviewed, getting the reports in on time. And I would say that I would hope that the court, in its infinite wisdom, would carve out some exception for those rare instances when we have situations beyond our control. And there are situations that certainly go beyond our control, where we find out an expert is way behind on getting his report finished or her report finished. But overall, I think what we try to do is inform our experts at the outset when we retain them. These are our deadlines. Our deadline, we know we have to produce an expert report 20 months from now or 22 months from now, whatever the deadline is. And once you constantly remind them of that deadline, they're typically able to comply. Again, I think those are really, that's the best way to practice. It's not always easy when you are trying to juggle all the other balls in the air, but I think everyone on both sides of the bar is actually doing a great job working well with one another. And I think this program has been extremely beneficial to both the plaintiff's bar and the defense bar.
And Judge Anders, is it okay if I come in now? There you go. And thank you, Judge Schulman and Judge Anders, Beth, and Heather. If I could just say a few remarks about the medical malpractice case management program. I guess I would just start by telling you my thoughts of what I think about the program, and then perhaps a few practice pointers. I know we call it the Medical Malpractice Case Management Program. I actually like to refer to it as the Pandemic Response Program because it truly was a response to the pandemic and the backlog that initially happened. But hopefully it will become the norm because we never want to go back to the days when 90 to 95% of our cases settled the day of jury selection or the morning of the first day of trial. And this program really eradicated that. Now, in terms of where we are in this program, we're resolving more cases, far more cases. We're resolving them sooner, resolving them with less time and effort in terms of trial preparation and less expense. And it goes without saying that in doing that, we're freeing up juries and we're freeing up judges. So it's good for the system. It's good for everyone. And we all need to find a way to keep this working. Just a few pointers if I can. We've talked a lot about getting those expert reports done in order to make all this work and to get to that pretrial conference and get an appropriate trial date. But I want to back up a little bit and say, none of this will work unless we do the legwork at the very beginning of the case. If the discovery isn't done right away, if the depositions aren't taken in the first 6 to 8 months, it doesn't work. If we're taking depositions in the last 4 to 5 months of the discovery period, we all know what happens. Someone's asking for an extension of time. And once that extension of time is either granted by the court or informally granted amongst counsel, what then happens next is the plaintiff's reports are extended. And then the defense reports are extended. And before you know it, we're getting that notice from Judge Schulman saying, hey, there's a pretrial conference and have your reports been done? And so that's the jam up. I mean, we've got to get the depositions done in the first, 6 to 8 months. And if it means going to discovery court, so be it. I'd rather not have to send our people over to discovery court, but that's where the push has to be in order to make this system work. And it will eventually lead to timely expert reports. But not only that, it will lead to discussions sooner. Because the sooner we have reports, the sooner parties know if it's a case that can settle. There are cases that can't settle. They're in a different category. But the cases that can settle, we need to discuss them early. At least what we're finding in our firm, the cases that can settle, when defense counsel tell us, hey, we want to get this case settled, pretty much every one of those cases settles. And it's just a matter of how do we get this done earlier. So if you are going to grant extensions, and this is pointer number 2, they can only be granted such that all of the reports are going to be done well in advance of that pretrial conference. And we plaintiffs, we have to give the defense lawyers enough time to get their reports in prior to that pretrial conference. So just be very intentional about how much time you give if an informal extension is granted. Then the third point I would make here is at the pretrial conference, I mean, typically we're not ready to discuss settlement, but we should at least have a concrete plan for how we will engage in settlement discussions after the conference. So in other words, we should show up to the conference saying, Your Honor, we're mediating the case in 3 months or in 3 weeks. Or Your Honor, we've already agreed we're going to use Peter Hoffman as our JPT, and here's our date. So when you call up opposing counsel to discuss a trial date, also discuss a date for settlement discussions, either with the JPT, either with a mediator, or even informal discussions amongst lawyers, but set a date so that happens. And then the last thing that I would say as a practice pointer is we all have to get the MCARE fund involved much earlier. In some of the bigger cases where we know it's going to involve a lot of excess insurance. So if it's an 8-figure case, we all know it's going to be an 8-figure case, and there's only one MCARE layer or 2 MCARE layers. There really is no excuse for waiting until, the day of jury selection or the first day of trial to get the fund involved. And I think Beth knows this. Unfortunately, I've had too many cases where it's the first day of trial. There's a jury in the jury room and we're waiting to open, but now we're waiting on the fund to make a decision about its layers, but they've just been told that we've agreed on the number and they haven't had a chance to review the case, and they haven't had a chance to adjust the case and to make a decision as to its layers. Now, I will give Beth a ton of credit. They move extremely quickly in those situations, but sometimes we can be waiting around with a jury sitting there for hours, a jury that could have been in some other courtroom. And so it's really helpful if we can just deal with the fund layers much sooner for a case that we know will settle and is going to settle well above the MCARE fund layer. So those are my comments. Those are my practice pointers. And I would just suggest that we now make this program the norm.
All right, so I think I've answered all the questions that were in the chat. I very much appreciate everyone's participation. We had almost 500 participants actually log in. We were close to 600 that had registered. This program is the new norm, just like 45 cases per month is the new norm. We expect this to be the new norm. And in fact, we've taken some of the lessons that we've learned on how to manage cases in the med-mal world, and we've applied them to other parts of the civil division. This is a work in progress, but we don't expect to back away from this program in any way. The last thing I will share with you is that Judge Schulman and I, from time to time, meet privately, either with the plaintiff lawyers or the defense lawyers or some of their clients. And we've done so with hospital systems. If there are representatives from insurance companies that are interested in meeting with Judge Schulman and I privately to share their concerns or their ideas, we're open to doing that. Of course, we're not going to talk about any specific case, but I believe in collaboration. I believe in transparency, and the door is open. You are our client, and we want you to understand we're here to work with you. I think I may have said this in May. Although you're our client and our customer, the customer is not necessarily always going to be right in this store. We still reserve the our authority to move things along in the way that we see fit, but we do want to hear feedback from you. So if you have ideas on how we can improve things, or you have concerns that's impacting you individually, understand, healthcare systems and insurers are all in different situations. We're here to talk to you. So I'll put my email.
Judge Anders,
yes, go ahead.
If we have another minute, I just wanted to respond to something.
Sure.
Do I have time?
Of course.
So
I'm sorry. And before we do, can we just bring Jen Schultz? I'm sorry, Jen Coatsworth back in before we do that. I very much appreciate the Bar Association. Let me have Jen just give one final wrap up, and then Judge Schulman will go back to you.
Thanks, Judge Anders, and thanks to you and Judge Schulman and all of the speakers today for this terrific program, which, as I said before, the Bar Association is really proud to host this webinar as a service to our entire legal community. However, a little infomercial here. If you're not yet a member of the association, or if you've let your membership lapse in recent years, we hope that you'll consider rejoining for member exclusive programming and benefits that will be further enhance your practice. And as I previously noted, our state civil litigation section has formed such a strong relationship with the First Judicial District, and they have monthly town halls with updates from the courts, and Judge Anders, as well as Pete Devone and Maureen Egan, frequently and almost routinely participate in those monthly town halls. We also present periodic CLE programs on the latest trends and top of mind issues in trial skills, case management, and best practices. And the section also has a medical legal subcommittee that focuses on the interplay between the medical and the legal sectors and the latest legislation that impacts the medical malpractice cases. We offer a lot of unique opportunities to interact with the judiciary on a personal level and in professional settings, and with your colleagues in professional social settings, including regular happy hours, as well as our annual bench bar conference, which we always get a great attendance from the bench. So you can learn more about the benefits of membership at www.philabar.org, or you can reach out directly to me if you have questions or would like to learn more about our association's work. I can be reached. I have an email through the Bar Association. It's just chancellor@philabar.org. And I look forward to hearing from you, and have a wonderful evening. Thank you, Judge Anders.
All right, Judge Schulman, final comments.
Just wanted to respond to a few things that Heather and that Rob said. And I saw a lot of questions about the rule hearings and sanctions. So to be clear, court sanctions are the last resort. They are the absolute last resort. If time gets short during discovery, go to your team leader and get an extension of your discovery time. That's where you're going to be asking for extensions of time. Because once you are finished, your case management order is what it is. You've gotten your extensions of time. And now what I'm doing is enforcing the case management order that you should be operating under. The next thing is, I saw there were questions about, well, who gets sanctioned? What if the defense delays? What if the plaintiff delays? The decision rests on the individual facts of each case. Has the plaintiff been the cause of the delay? Has defense been the cause of delay? Those are the things that get discussed at those hearings. And as I said, we've had less and less of those situations. And finally, even at the rule hearing, if you tell me that, well, we just need another 15 days for plaintiff's report and then another 15 days thereafter for defense report, you'll get that. Sanctions may start right after that if that's not what actually takes place, but you will get that. And then the last thing is that you can't choose your JPT. I know we all love Peter Hoffman, but you can't choose him. Your JPT is really dependent on everybody's schedules. Thanks.
Okay, well, we're going to close out now. And before we do so, I just want to make sure that everybody understands that that is not Rob Ross's office. He has a much more elegant office. He's on trial in City Hall, and I stuck him in at my law clerk's desk. So, you know.
Thank you, Judge, for the use of, thank you for the use of the space.
So anyway, nice to see everyone. Thank you very much.